Welcome to the video clip. My name is Marty Schenkman. I'm joined by a friend and colleague, Jonathan Blotmacher, and we're going to talk about a really, really important topic. And I don't think it gets enough respect, and I think it is really critical to much of estate planning that many people do. Trustee selection. Who are you going to name as a trustee? Please bear in mind, as with all video clips on Law Easy, these video clips are for educational purposes only. Do not take any action without consulting appropriate advisors. And again, with trust, laws from state to state differ dramatically, so it's critical that you have appropriate advice in the state where the trust is going to have situs and governing law apply. So, Jonathan, we made up a list of people that can be named as trustee. Let me run through the list, and then let's talk about why the selection is so very critical to the essence of everything a trust is trying to do. So you can name, in certain cases, the individual who's setting up the trust or grantor, settlor. In a lot of cases, that is just not possible. It will completely undermine the estate tax and asset protection benefits of the trust. Some people name spouses. Some people will name the husband on the wife's trust, the wife on the husband's trust. Family members, children are often named. Friends, right? You name a friend. Keep in mind that whoever's your friend today may not be your best friend tomorrow. You can name a professional. I see attorneys and accountants frequently named as trustees. You can name an independent trust company. There's certainly a long list of possibilities. Before we talk about how this affects every aspect of a trust, I want to tell you what my default is for planning for my clients, and it's the plan that I use for my own family. I strongly prefer to name an independent institutional administrative trustee, Peak Trust, Premier Trust, South Dakota Trust. I like naming an independent institutional trustee for a tremendous number of reasons. My personal trusts are all in Alaska with Peak Trust as the trustee. Why don't you go through some of these benefits and considerations of who you select? And I think in the end, it's going to become clear why my default plan is not to name my best buddy who lives in New York, which is a high tax state, or myself or my spouse, which can create other issues. What are some of the things that are
Marty,
impacted by selecting a trustee?
one of the things, if you name yourself as the trustee, you may not get the asset protection you want, even if you're not a beneficiary. I worry about that because the court will do whatever it can to take money away from the trust in the appropriate circumstance. So you have a trust for your spouse, and you and your spouse have a fight, and all of a sudden you thought this thing was completely protected by the claims of creditors, but it may not be, because the court views you and your spouse as one. And in fact, we have down at the bottom, don't violate the reciprocal trust rule. If Marty creates a trust for Patty and Patty creates a trust for Marty, and they do it at approximately the same time with the same assets, same provisions, it's almost certainly going to fall under the reciprocal trust doctrine. So Marty will be treated as the creator of the trust that Patty actually created for him, and the reverse. So you're going to lose asset protection, which is one of the critical reasons to have a trust. In addition, the courts have indicated that if you want to keep something out of your estate, one of the factors they will look at is who is the trustee. And if you have an independent trustee, the courts are going to look at this in general in a lot more favorable light. Also, if you choose a trustee in many, many states, you're going to wind up having to pay an income tax to that state. For example, California says, we don't care who are the beneficiaries. We don't care whether or not this person ever went to Disneyland or not. The fact that you have a California trustee means that California believes it can tax the trust on all of the undistributed income. It also can affect what the federal income tax consequences are. For example, if you want to make sure that you're not going to have income taxed to a particular person, well, if you have a trustee who's independent, that trustee may be able to send that income over to an alternative beneficiary and reduce overall taxes and also gain asset protection. Critically important to consider. Now, many trusts use a distribution standard where they say, well, this is a trust for my children, and the trustee can distribute for health, education, maintenance, and support. And that normally will mean that that provides protection for the beneficiaries because the HEM standard is not considered a general power of appointment under Section 2041. The problem, however, is that you may be limited on what you can do. And you'll have to maybe go to court. I had to do this one time when someone brought in a trust and said, we want to give money to mother so she could do estate planning. But the husband who had created the trust had put in a HEM standard. We did get the order from the court that, yes, giving her money in order to allow her to do important estate planning was consistent with the standard of health, education, maintenance, and support, but it cost us tens of thousands of dollars to get it. And a number of lawyers who saw that decision said it would never happen in my state. So I recommend that you be careful in the choice of your trustee and not attempt to use a standard. And again, you want to do this in a manner so that you're not going to violate the reciprocal trust doctrine.
The default in many old style trust plans was if you set up a trust for a child, you would name the child as the sole trustee of their own trust. But in order for a child to be a trustee of their own trust, you had to limit what they could distribute to themselves by health, education, maintenance, and support, or HEMS. And that is still something that's used where you have a very small dollar amount and it's all you can do, but it's not the type of asset protection you want. Contrast that to a independent trustee, an institutional trustee, where there's a purely discretionary standard. If the IRS wants to make an argument, if a creditor wants to make an argument, you're going to peak trust and saying, you institution, make a distribution. No, we're an independent institution, and it's our discretion if we distribute, when we distribute, and what we distribute. In
Marty,
Levine,
you're absolutely correct, Marty. And one of the places where people get hung up is their parent has created a trust and they've used a HEM standard because they say, well, that prevents it from being a general power of appointment. Well, it will under federal law, but it does not necessarily happen under state law. There's a case in New York called Matter of Flood, and Mitchell Gans and I wrote a statute for New York, which was enacted, which overruled the state. But the court said that the fact that the beneficiary could take money out for health, education, maintenance, and support made it subject to the claims of his creditors. Other states have different rules, and you may feel completely protected. But here's what happens, Marty. Let's say the son is in a divorce and his wife wants money, and the husband says, I don't want to give it to you because, I have no entitlement to it. But the court might say, Mr. Smith, guess what? I'm going to force you to distribute things to yourself. Now, you
under
might
the
say, well, that would
HEMS,
be, pardon?
under the HEMS standard.
Under the HEM standard,
Yeah.
because this is part of what you've got to provide for your divorce or divorcing spouse or for your children. So don't think that naming the child as a trustee with a HEM standard is going to provide protection. It is not a good idea. Now we're going to come to something else about removing trustees where maybe you'll provide a little bit more flexibility in order to allow the child to participate in things. Keep
We're,
in
we're out
mind
of
that
we're out of time, so we're going to have to wrap up, Jonathan. But really a critical point, and I think that many people really need to rethink who they've named as trustees. We've given you an overview. There are just so many critical objectives of almost every trust that can be enhanced by better selection of who the trustee is. And I don't even think we mentioned, Jonathan, it was just say quickly, state law. You can get yourself into a better state law and better tax and legal protections by doing it. Keep in mind that when you name a trustee, you also want to provide a mechanism to remove that trustee. I want to thank Jonathan for his insights and comments. Again, please keep in mind that all the video clips on Law Easier for educational purposes only. Thank you for joining us.